The Independent Electoral and Boundaries Commission now wants the High Court decision declaring that it is declared IEBC not properly constituted to carry on with any of its mandate, be it setting aside pending its appeal. In an application, it once certified urgent IEBC Chairman Wafula Chebukati, who says last week's orders risk plunging the country into a constitutional crisis. Samogina reports.
The electoral body becomes the first aggrieved party to challenge last week's High Court decision that also put brakes on the BBI process. IEBC has moved to the appeals court seeking a stay order on the 5-judge bench decision. In its appeal, the electoral agency said the judgment could plunge the country into a constitutional crisis. The 5-judge bench concluded that as currently constituted, with only 3 commissioners out of 7, IEBC was not properly constituted to carry on with its mandate as it lacked the requisite quorum.
We also conclude that the IEBC Act categorically places the quorum of IEBC for purposes of transacting business at 5 commissioners. Finally, we conclude that the IEBC did not have this quorum at the time it made the consequential decisions related to the Constitutional Amendment Bill. It therefore follows that all the decisions so made by the IEBC in relation to the proposed constitutional amendment, and in particular to the Constitutional Amendment Bill, were invalid, null and void for lack of quorum.
But in a rebuttal, the Electoral Commission fell short of deconstructing the decision. IEBC said the judges in delivering their judgment applied the wrong principles in interpreting the provisions of the Constitution and the law, and thereby arrived at the wrong conclusions. And in declaring the Commission not properly constituted, the court was throwing the Commission's work in disarray. IEBC, in its petition to the appeals court, says the effect of the orders by the court will cripple its operations, including carrying out by-elections. Already, the Commission has concluded the Bonchari, Juja parliamentary by-elections and Rurie ward by-election. Other pending by-elections include Kiambaa parliamentary by-election and Muguga civic ward by-election. Seeking orders against the decision, the electoral agency stated there were ongoing and impending by-elections whose timelines are cast in stone, and a constitutional crisis would ensue unless the appeals court intervenes. With the High Court ruling that IEBC required to undertake fresh voter registration to precede the referendum drive, the Commission argues the voter registration exercise is a continuous process under the Constitution and the law, and no evidence was placed before the court to suggest otherwise. The Commission further states the decision will jeopardize preparations for the 2022 general election. IEBC said it is expected to undertake certain fundamental preparatory works towards the 2022 general election. And unless the appeals court grants the stay orders, the whole process will be thrown into a limbo and the general elections compromised. BBI proponents and Attorney General have also indicated the intent of challenging the decision of the 5-judge bench that has put brakes on the constitutional amendment process. Samogina, Citizen TV, Nairobi.